Good morning, everyone. This is Shashank Mishra, presented as the host of ninth episode with renowned senior advocate of Supreme Court of India, Subodh Markandeya, on topic Uniform Civil Code. On this notable heading, the first question is: Uniform Civil Code is so much in now news today. What is the constitutional roots?
Article 35 of the draft constitution, which was submitted to the Constituent Assembly by the constitutional advisor, Sir Benegal Narsingh Rao, dealt with the subject of Uniform Civil Code. When it was enacted, it became Article 44 of the Constitution.
Can you kindly tell us in brief about the details of debate in the Constituent Assembly on the subject?
So, Article uh, 35, as it was debated in the Constituent Assembly on the 23rd November 1948 and is contained in Volume 7 of the Constituent Assembly debates at pages 540 to 552, total 12 pages. So, some amendments were proposed by Sarvashri Muhammad Ismail Sahib, Naziruddin Muhammad Ali Beg Sahib Bahadur, P. Pokar Sahib Bahadur, and Hussain Imam. These were all separate amendments, the purport of which was to exclude the so-called personal laws from the purview of Article 35, now 44 of the Constitution. That is to say, uh, the purport was that uh, uniform civil code should not override the personal laws. That was the purport. Now, Mr. Sri K. M. Munshi, while participating in the debate, pointed out that opposition to the Uniform Civil Code had come from some staunch Hindus also. But he pleaded that in this matter, members should give up isolationist attitude perpetuated by the British rule as part of their divide and rule policy. He further told the House that 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 when the bill to enact Shariat Act was introduced by the British rulers, it was bitterly opposed by some communities of the Muslims faith, that is Khojas and Kachhi Memons. These communities were till then being governed by Hindu law in all the matters of their marriage, succession, guardianship, adoption, etc. Sir Alladi Krishnaswamy Iyer, participating in the same debate, drew attention to the European nations which did not perpetuate different religion based laws to deal with secular matters like marriage, divorce, succession, guardianship, and custody of children. Replying to all the debates in the Constituent Assembly, uh, Dr. B.R. Ambedkar, who was the pilot of the Constitution, asked if the laws relating to criminal procedure, penal code, contracts, negotiable instruments were not governed by personal law. He asked this question. Then why not marriage, succession, etc.? These are all uh, matters of what may be called secular matters. So they should not be governed by religion. He reminded the House that before the Shariat Act was passed in 1937, Muslims were many Muslims in most of the Muslims in the northwest frontier province were governed by the traditional law, and many communities were governed not by Sharia but by Hindu law in Bombay Presidency, Central Provinces, United Provinces, etc. He also pointed out that in Malabar, Muslims themselves followed the local Maruma law. Now, all these Amendments were put to vote and they were defeated. The motion to include Article 35, which is now 44, was adopted as proposed, that is to say, after defeating all the amendments. This is contained at page 5, 552 of the Constituent Assembly debates in volume 7. So, the clear implication of the debate is that the Constituent Assembly intended to override personal laws by the operation of the Uniform Civil Code. Otherwise, the whole purpose of Uniform Civil Code would be defeated.
So what is the correct approach to interpret Article 44?
You will recall that in our conversation on Part 4A, Fundamental Duties, I have already stated that the interpretation placed on Part 4 by Justice O. Chinnappa Reddy in Uttar Pradesh State Electricity Board versus Harishankar Jain is the most appropriate interpretation. That is to say that provisions of Part 4 are fundamental to the governance of the country and they must be ever present in the minds of the judges. Addressed to the courts, they mandate that the courts should evolve, affirm, and apply rules of interpretation which advance and not hinder the provisions of Part 4 of the Constitution.
And has it any cases come up before the Supreme Court about Article 44?
Two cases immediately come to my mind. The first is the famous Shahabano case. There, Chief Justice Y.V. Chandrachud reminded the central government that 35 years after the Constitution came into force, it has taken no steps to enact the Uniform Civil Code as mandated by Article 44, and that is why this strange situation has arisen in that case. And therefore, he observed that central government should take immediate steps to enact Uniform Civil Code. The second case which immediately comes to my mind is Sarla Mudgal's case. There, what happened that four Hindu women came to the court. They married their husbands as per Hindu law. Their husbands only for the purpose of contracting second marriage, even during the subsistence of their first marriage, converted to Islam. So the question which arose for the consideration of the Supreme Court were whether the second marriage was void and whether they were guilty of the offense of bigamy. Answering both the questions in favor of the wives, it was held that marriages were void, conversion to Islam was fraudulent, and they were guilty of bigamy. So, in that context, uh, Justice Kuldeep Singh directed the central government to take immediate steps to enact the Uniform Civil Code at the earliest.
Chief Minister of Uttarakhand has recently said that legislation to enact the Uniform Civil Code will be brought by his government. What are your views?
In my view, Article 44 envisages uniform civil code for the whole country and not in any peaceful manner. Hence, Parliament alone can act in pursuance of Article 44. Whatever bill may be introduced in Uttarakhand Assembly may not be in pursuance of Article 44. It may be in exercise of its legislative power to enact laws relating to uh, marriage, divorce, maintenance, custody of children, etc., etc. But it can't be called a law in pursuance of Article 44.
Thank you, sir. That will be was my last question. And we will be next see you in the next video, sir.
Thank you very much.